Good morning, everyone, and welcome back to the second day of the European Ideas Forum. I remind you that you can join the debate by using the hashtag EIF21 on social media. You can follow the discussions on the Martin Center website, YouTube, Facebook, and Twitter. We will start our day by discussing all things digital. To help us do that, I invite you to answer the following poll on slido.com using the event code EIF21. Regulating large platforms through more obligations and prohibitions is good for the EU digital economy. But without further delay, I'd like to give the floor to Eline Chivot, Senior Advisor at the European People's Party, who will moderate today's first discussion, Europe's Digital Decade, Regulate and Chill. Eline, over to you.
Well, thank you very much, Anna. Good morning and welcome to you all. Today, I'm Eline Chivot, Senior Advisor on Digital Policy at the European People's Party, and it's a pleasure to have you with me today at the European Ideas Forum of the Martin Center. I hope that you will enjoy our conversation today during the next hour on the ambitious topic, Europe's Digital Decade, Regulate and Chill. To get us started, a bit of food for thought first. The EU has tried to solve very complex challenges when it comes to tech policy, rolling out an ambitious agenda, and the EU is now recognized as a global standard setter when it comes to regulating the online environment, from personal data to AI and competition policy. Of course, these frameworks require continuous efforts in terms of implementation, compliance, and keeping pace with the rapid evolution of the online landscape and of the technologies around it. And at the heart of the approach, what the EU wants to do is to ensure that we maintain and improve our competitiveness, our innovation, our growth, but that also means protecting the market from the side effects of the domination of certain large non-EU tech companies, which in some respects have been shielded from the rules of the game that the EU wants to set. So there's also this need for constant change and update of our frameworks to keep up with that speed and that competition. But piecemeal legislation, some say, is unlikely to be efficient, and European regulation alone may not hold unless we are more ambitious in terms of stepping up and nurturing our own strength rather than just regulating the strength of others. So for the next decade, will we see the roaring 20s also in the digital area if we only regulate and sit back? To discuss all this today, it's a pleasure to introduce you to four speakers. One of them will join us a little later. Thank you all for joining me today to discuss this. Paulnimitz, you're a Principal Advisor at DG Just at the European Commission. Thank you for being here.
Happy to be here.
Thank you. Evangelos Ouzounis, you're the Head of Unit for Secure Infrastructure and Services at the European Union Agency for Cybersecurity, or ENISA. Thank you for joining us.
Thank you for inviting me. Good morning.
And we have Hendrik Bourgeois, Head of Government Affairs for Europe and Russia at Apple. Thank you, Hendrik, for being here.
Thanks for having me. Good morning.
Andreas Schwab, who's member of European Parliament for the EPP Group, will join us in a few minutes. But first, I'd like to ask you, Paulnimitz, your thoughts on today's topic.
Well, my thought on today's topic is that, first of all, it would be very wrong to describe the European Union either as an institution which only regulates. That's absolutely wrong. We have huge budgets which we're spending on technology research and development. 20% of the COVID recovery fund will go into digital, but we also have programs of billions of euros for AI development in the European Union. But secondly, I think it's also not good to describe Europe, constantly as a lagger in technology, because that's both wrong and discouraging. I think it's much better to point to the fact that although Google, Facebook, and let's name them, are very big players, and Microsoft too, and Apple and Amazon too, very top of the US stock exchange, there are really a lot of European companies which are very innovative, very competitive, and we have just seen it in the COVID crisis. Where do the vaccinations come from? They come mainly to Europe. So I think it's wrong to describe Europe as a loser when it comes to innovation. The opposite is true. there is a division of labor, of innovation, and some innovation is better in the United States in the digital, and I've just mentioned some of those companies which have been very successful, but there's a lot of digital innovation in Europe too. And I would agree with your thesis. We need to both constrain the power of the big players. We need asymmetrical regulation, and a lot of that is now on the table. And at the same time, we need to empower research and development in Europe, and we need to empower people to get there, to work with these technologies, and to get knowledgeable about them.
Oh, thank you very much. I'd like to ask you a follow-up question, because you said it's wrong to say that we're only regulating in Europe, but you know, where are we making progress and finding solutions that are not involving regulatory responses currently?
Well, there are many areas. As I said, you know, we are investing heavily into research and development. It's probably fair to say that in terms of digital infrastructure, namely, you know, building the networks, fiber optics, and so on, Europe is, you know, in different ways in different member states, but some of our member states are world leaders in this. We have technology companies who are very competitive when it is about building networks. So also security technology, much of it for cybersecurity, and I'm sure my colleague from ENISA will talk about it, much of that comes from Europe. So there are really many examples. And let me mention last, there's a lot of American money now flowing into startups in Europe. You know, London, Berlin, Paris, and other cities in Europe have become startup capitals with a very thriving startup scene. We see a lot of Israeli technology development companies, and Israel is a leader in many of the digital companies, also setting up in parallel in Europe. So there is really, if one wants to see it, there is a lot of good news. And there's a lot of opportunities which the European Union is providing, both on the, let's say, macro level in terms of infrastructure measures together with the member states, but also on the micro level in terms of direct aid to companies, for example, the Horizon 2020 program. There's a lot in it for digital players.
Thank you very much, Paulnimitz, for your contribution. And you're right, I've actually come across an article this morning saying that VC investment in European startups has reached a record high. We have with us Andreas Schwab, member of the European Parliament for the EPP Group. Welcome, Andreas. Thank you very much for being there. I'd like to give you the floor with no further ado.
Good morning. I'm connected from Andorra, and I hope that you have an excellent connection and that you can hear me.
I can. The floor is yours.
I would like to thank the Martin Center for that very topical debate. I think it's very, very helpful that we exchange in all directions on the topic of how to make this law a law that is fulfilling the hopes of not only European citizens, but also a lot of American and even beyond in the population. There are expectations that digital markets get fairer. But by getting these markets fairer, it's not about making them more regulated or more bureaucratic, because the key driving factor, and I have been speaking, Eline, I have to tell you, I've been speaking to lots of innovators, to lots of young people that want to make their business, that want to develop their own ideas. It's about giving these people the chance to fulfill their own expectations and to make their business a reality, to feel free in the globalized digital world. And for that reason, we have to find the right rules. And I think it has already been said in the panel so far, we have to make the right rules for the 21st digital century, to make this century a globalized and fair time. And I think we have all the chances now in our hands, because we see on both sides of the Atlantic, but even in Japan and in Australia and other parts of the world, a very thorough reflection on how to make this possible without making the markets too regulated. And that's, I think, our common aim.
Thank you very much, Mr. Schwab. I have a small follow-up question, if I may. So we're regulating a lot of industries. We've done that with food, with cars, with airlines, and we're now regulating tech. But that is not going to be easier or more simple than regulating any other kind of policy, really. And there's a lot of trade-offs that we have to take into account, that you have to take into account as a policymakers. How differently is it to regulate tech from other areas, and how different is our approach in Europe compared to, the United States or other nations?
I mean, what we are doing here is, technically speaking, not really regulating. What we want to do is setting brakes to companies that are far too dominant and that have a control over tipping markets. That's different compared to telecom regulation, for example, where we had lots of cables, lots of mobile phones that were at specific moments getting together. Here, it's a bit more general. And I think we are not focusing on the companies like in tech. We are focusing on the markets. And we want apply the general principles that we have in Europe already in place, but that these principles in a digitalized world could not be applied anymore. We want them to be applied on beforehand. And I have to tell you, if I look on the debate that is happening also in the US around the Silicon Valley companies, we have to recognize that there are plenty of brilliant people that have themselves a feeling for what is fair at the moment and what is unfair. And I'm sure that with the rules that we are setting, we will give them also a direction, what is fair and what is unfair. And there will be also a new compliance culture in these companies that will help to make the digitalized world better. So I think if we get it right, we have a unique chance to show that the economy is there at the service of the citizens and of the users, and not only on the shareholders of specific companies.
Thanks very much, Andreas Schwab. Now it is going to be for our third speaker to take the floor. I would like to ask you, Evangelos Ouzounis for ENISA. What is your kickoff for today's topic?
Yeah, so technology is always evolving, and there are always new challenges and new issues in new areas. And in some of these areas, there are, policy challenges, and it is, I think, the responsibility of the European Commission, to understand the gaps, to understand the issues, and together with all the other decision policy makers, to come up with some interesting proposals, to address them. This is what is happening over the years. Most of these regulations are not necessarily defensive, and they are not here to defend, European interests against the interest of others. They are solving practical problems. And I will mention a few examples, like for the NIS directive, which is a regulation for, it's a directive for network information security, and actually helped a lot to develop a common level playing field for the member states. A lot of countries use this and as a basis, to do investments, to put a structure, and we have seen a dramatic improvement, over the years. And this is an example, which is not necessarily, protecting interests of the European Union, but helping, member states, helping the private sector, addressing real problems. And I think most of the policy interventions are in this direction. Second point is what Mr. Nimitz said, that I think it's wrong to focus only on the policy part. There are so many other things happening in Europe, I mean, we have a very long tradition in R&D in Europe at national, but also at the European level. Billions and billions of euros are being spent, to come up with new technologies. The problem, if I can say this, is the commercialization of the research, and this is where Europe is lagging a little bit behind. Used to in the past, but now it's getting much better. So we were working for years and years, in Brussels, to develop the mechanisms for commercializing research results. And now we see an important, with startups emerging in different parts of Europe. And this is absolutely great. So this gives us great confidence, that things will improve. The third is obviously the internal market. Here, we have in theory a market like the one of the US, but it's not one united, unified single market. So that's why there are interventions, in this direction to improve, to correct here and there, aspects which are, for example, streamlining, let's say, the internal market, and develop through these European players, European champions. And I will give the example of the certification, which was added in the CSA for ENISA, in the Cybersecurity Act, which gives ENISA the role to certify particular aspects, particular areas that will sooner or later develop European champions. And with the size of the European market, with a unified single certification mechanism, then we might be able to develop big product developers that can compete at the global level. We are correcting this as well. I wouldn't call this also a defensive regulation. There are, as Mr. Schwab said very nicely, there are other areas where indeed Europe has to take a little bit of a defensive approach to this. But doesn't mean that whatever we do is always policy and whatever we do is a defensive policy. And there are many more things than developing legislation, I believe. Thank you.
Thank you very much. I have a quick follow-up question, actually two of them, but I'll try to limit to one if I can. Well, we just heard that LinkedIn suffered from a huge data breach this week, and maybe that platform may not be the best example to take, but what I mean is that a lot of our companies in Europe depend on those big platforms, right? And if even they cannot ensure, that they can manage cybersecurity threats, then do you believe that we can provide solid alternatives to those huge platforms that will be more secure?
Yes, we can. And yes, we can be better on cybersecurity and privacy matters. And I know that, companies are in their interest to do this. Because cybersecurity becomes a competitive advantage. A lot of companies are using it as a product differentiator, and this is very, very important. They take ownership and they demonstrate that they are, following good practices. They comply with standards, and it's not only a matter of size. Size doesn't give us the reassurance that things are more secure. So we are going to face cybersecurity and privacy challenges in the future. And indeed, big players have financial strength to invest on cybersecurity, but doesn't mean that size means better security. And there are a lot of other players, European players, which are equally secure or maybe even better. And we can definitely trust them, for doing such kind of transactions.
Thank you very much, Evangelos. Ouzounis, now it's your turn. Hendrik Bourgeois, Head of Government Affairs at Apple. I'd like to hear your take on today's topic and also maybe your first reactions to what you've heard. Do you agree that the EU's policies and digital agenda are supportive and not defensive when it comes to, you speaking from an industry's perspective?
Thank you, Eline. Thanks for having me again this morning. It's a privilege to be able to participate in the discussions. Look, I think how to assess the ambitious digital strategy of the European Commission is a very good question. I would say, I'm picking up also on the comments that were made by the previous speakers, I would say four things. Number one, I think it's extremely important to increase digital skills in Europe. There's a huge gap, and it's an imperative, simply an imperative to integrate digital skills in educational systems more and better to prepare for the future, but also to unlock investments and to increase productivity. I mean, the digital compass of the European Commission has identified that 80 or 70% of European businesses find that the lack of digital skills constitutes an obstacle to digital investments. And so that's something that the European institutions need to work on together with member states. And certainly a company like Apple tries to contribute to addressing that challenge. We are partnering with institutions, universities in Europe. For instance, we created an app developer academy in Naples that graduates hundreds of students in digital skills and coding and entrepreneurial skills. So digital skills is of critical importance. On the point of regulation, I agree with what Evangelos said and what Paul said. I think, regulation for sure has a vital role to play in promoting, digital sector in Europe, a vital role to play. And the best example I can think of is regulation that is geared towards increasing, deepening, broadening the digital single market, because it eliminates barriers to investments and barriers to trade between member states of the European Union. And that's incredibly important. And a good example of this is the DSA, the proposed DSA, Digital Services Act, because it enshrines and embraces the principle of country of origin, without which we would see fragmentation in the digital single market, because countries would be applying different rules or interpreting rules differently to preserve the legality of online content. On investment, I agree we should not be too negative, but we also should not be complacent. Commissioner Gabriel, for instance, a few weeks ago pointed out that the share of global venture capital that invests in European startups amounts only to 8%. 8%. That means that 92% of venture capital is investing in non-European startups. Yes, we're investing in Europe in artificial intelligence, but I think the number amounts to 2 billion a year. China invests 4 billion a year, and the United States invests 8 billion a year. And so what Europe needs to do, I think, in this respect, is to complete the capital markets union to unleash more private sector investment in the digital markets. And then the last, but the important point I wanted to mention as well, which I think is of great importance, is that the Commission itself in a digital compass, agrees that the starting point of the European Union is an open digital economy. That means that Europe needs to continue to be open for international foreign investments, foreign and international trade, and international partnerships. And I would like to mention in particular the transatlantic dimension here, which I think Andreas was alluding to. And I think the Commission should be commended and congratulated for taking the initiative of creating a transatlantic technology council, because I think it holds the promise of developing global norms, global rules, global standards for the digital sector, but that are based on shared transatlantic values.
Well, thank you very much, Hendrik, for highlighting the need to complete our digital market and our capitals market, and also remain open and also invest in digital skills. Briefly, thank you for mentioning all these acronyms, DSA, because I had the DMA on my mind, as we have Andreas Schwab with us today, who's rapporteur of the Digital Markets Act. And you talked about fragmentation, Hendrik, and Mr. Schwab, perhaps you could comment on the fact that, we talked about the global approach of Europe, but also within the EU, you might be struggling with existing laws that, different countries already have, that might have a complicated relationship with the digital file that you're carrying. The German competition chief also commented that maybe the Commission doesn't have the manpower that's necessary to implement this law properly. What is your response, and what is your plan on addressing these concerns and potential conflicts?
Well, my concern is that in the end, we have to get the legislation that is treating equally all participants. And it's obvious that we are focusing on the problems with that legislation. We are not doing legislation because we are bored. And the problem that we have been seeing and observing was that competition policy was too often running behind developments, and too often with measures that were having too little consequences and too little outcome. And to change this, we do that legislation, and therefore we don't do it to jeopardize SMEs or young innovators. We do it to make sure that the market gets fairer and better and more innovative again. And therefore we are focusing on the biggest companies. And focusing on the biggest companies can only be done on the basis of what Emmanuel Macron is always referring to, that if we want to defend our sovereignty, then we can only defend it together. So we need full harmonization. We need one law that is applied all over the place in the same manner, and not under the criteria of one of the national authorities only that have some specific points of views, but under a common understanding, going from Finland to Portugal and from Lithuania to Ireland. And the truth is they're always a bit in the middle, and therefore we have to go for a harmonized system. And the DSA, unfortunately, therefore, is not the best proposal, because we have seen with General Data Protection Regulation that a too much heterogeneous system, where member states don't really want also to fight in courts about the European approach, makes Europe weaker than we are. So the question will be, how can we make a harmonized system that uses all the resources that are at the disposition of us in the European Union and in the member states? And so the cooperation between the European Union and member states will be crucial. And I have just written as a rapporteur of the DMA a letter to the European Commission and to national competition authorities, that they come up with proposals even to improve how this cooperation can be boosted. And I'm looking forward that we can get it done. And then I would like to come back on what has been said already. In the end, having a different approach, what a gatekeeper is in the US or in Europe, would be a bit strange, because in the end, we want to have a better market in the US and in Europe. And therefore, we will have next week also an exchange of views with our American counterparts in Congress to discuss with academics about their recommendations on how making these markets, let's say, fairer, even, and fairer. And we will see what gets out, but I think it will be of utmost importance to try to find a common approach on this in the interest of the citizens all over the world in the end.
Thank you very much. I think you are also proposing this high-level panel, to ensure there's better cooperation between EU authorities and member states' authorities. Now, still on the DMA, and before we turn to our audience, I'd like to get back to you, Hendrik, because a few weeks ago, Tim Cook said that, although the DMA was overall taking a positive approach, he said that it could lead to privacy and security risks. He mentioned something about sideloading, and I was wondering if you could explain a little bit better what is the problem and to what extent would that consequence of the DMA should be something we should avoid?
Yeah, thanks for that question, Eline.
You're on mute.
So Apple is, I am on mute?
There you go, I can hear you.
Okay, sorry about that. Thanks for the question. So Apple is a company that keeps the interest of the consumer central in everything what it does. It focuses on the consumer experience, but also on the privacy, the safety, and the security of our consumers. It's really an obsession at Apple to protect the consumer. And we also have a curated approach towards putting content online. That means that we have human professionals, not algorithms, human professionals that review apps before we put them on the App Store. And we look whether those apps are obviously legal, but also whether or not those apps are risk endangering the privacy, the security, and the safety of the users of Apple devices. And we call that a curated approach. And that approach has functioned very well because it protects essential rights and interests of our consumers. And the DMA, as proposed by the European Commission, proposes to mandate so-called sideloading, which would basically mean that Apple, for instance, would have to allow consumers to download apps directly from the internet, and in that way bypassing these essential and incredibly important safety, security, and privacy mechanisms that Apple has put in place. And we think that's a bad idea. We think that would reduce and degrade not only the consumer experience, but also the safety and the privacy of digital users and also digital businesses. And so I think it's very important at the end of the legislative process, and that's why, you know, people like Andreas have a very important role to play here. At the end of the process, that, you know, legislators and EU institutions can guarantee to European consumers and European business users that the DMA is not going to reduce privacy, safety, and security protections. And that is why I think my CEO, Tim Cook, had made that comment last week. And we hope, of course, that during the legislative discussions in Parliament and in Council, that this issue will be addressed.
Thank you very much, Hendrik, Bourgeois. Now I would like to turn to Anna and give you back the floor for our audience responses to the Slido survey.
We do have the results back from our poll, and the overwhelming majority thinks that yes, regulation is a good thing for the EU's digital economy, but to the extent that it's not adverse for consumers and business users. I also have a couple of questions from our online viewers. The first question asks, do you think some member states may have reservations or difficulties implementing the Digital Services Act and Digital Markets Act? Ireland comes to mind, and its many tech companies. And the second question is, regarding digital policies, how important it is to have harmonized measures at the EU level to protect citizens? Eline, over to you for the answers.
Thank you very much, Anna, and thank you for these interesting questions. I believe that we have addressed partially through MEP Schwab those questions about the potential difficulties that implementing these proposals will have. So maybe I'd like to have your take, Paul Nimitz, on this question of implementation across the EU and reservations of member states, and also the importance of harmonized measures, if you don't mind giving your perspective.
Certainly. So I think the issue today is free riding. And there are two types of free riders. First, if we have rules which are not binding, so voluntary self-regulation and so on, then we have some companies who want to do good, but many are not, and they are the free riders. And that's a problem, and that's why it's good that we're moving to binding regulation for all. In some cases asymmetrical, meaning the bigger players and the more powerful players, and this is about power, have more obligations than the other market participants. That's the first point. But there's another type of free riding, which is to participate as a state in the European Union system and have to have the benefits of the internal market, but then not play ball when it comes to protecting all citizens through the enforcement of the common law. And this is an issue which we need to address in Europe. And it's both an issue of law, how the law is constructed, but it's also an issue of attitude. To say it very clearly, the enforcement authorities today, the national enforcement authorities, whether they are national judges, national competition authorities, national data protection authorities, and also the future digital coordinators under the DSA, all of them should not see themselves as national authorities anymore, because all of them have the duty in relation to the companies which have a seat in their country to enforce the law for in the name and in the interest of all citizens in Europe. So these authorities become European authorities. So it is wrong that the Data Protection Authority of Ireland sees itself as a national data protection authority. No, it has the duty to protect all citizens of Europe when it comes to data protection in relation to the companies which have their seat in Ireland, like most of the big GAFAM have. And the same is the case, of course, in Luxembourg, and for that matter, in any other member state. And this is something which we must bring home to the governments and to the authorities. And if it doesn't work through a culture change, and through goodwill. And I'm still hopeful that there is a development possible here, because we have seen it with national judges. National judges have really understood this. The judges of Ireland, they have understood. They are protecting people from all over Europe, and that's why many of the great preliminary requests for ruling to the European Court of Justice come from Irish judges. But if these systems don't work on the basis of good understanding and culture, if these authorities are not helped and don't manage to take up their European vocation, then we must change the law. And I already see that, for example, in the DSA, the mix between central and decentral enforcement is different than in GDPR. I think I'm very much in favor of having a good culture of cooperation and trust, that all citizens must be able to trust all authorities in the member states, and in particular citizens from other member states, because they are the ones who call them for help. But if this doesn't work, well, then in the end, the only solution is that we have centralized enforcement. And I would say there are also some good arguments in favor of strengthening central elements of enforcement, in particular when it comes to the global big players. It is a little bit, let's say, it can be seen as a little bit naive to think that with the biggest companies on the stock exchange, which I call the GAFAM, Google, Facebook, Apple, Microsoft, Amazon, we have these 27 authorities dealing with them. And no, if that doesn't work, and in some areas there are signs that it hasn't worked or will not work, then we must move to central enforcement. And, the United States is an example. The FTC is a very strong enforcement body, by the way, an enforcement body which brings together both competition law and privacy enforcement. And this is another point I would like to make at this occasion. We have a huge fragmentation between sectors of enforcement in Europe. For every piece of law, we have specific enforcement bodies. But the digital economy is an all-purpose technology economy. It's an economy of platforms which are present in many sectors and do many different things. And so I think in the longer run, we also have to rethink this sectoral fragmentation of enforcement bodies. We may have to bring enforcement bodies together for digital purposes. So to conclude, two issues of free riding and fragmentation, the geographic issue and the sectoral issue, and both need to stay on the agenda.
Thank you very much, Paul, for addressing the audience questions so well. And I saw that MEP Schwab, you were giving the thumbs up and nodding, so I'd like to have your reaction perhaps on Paul's thoughts. And also because we're talking about fragmentation, free riding, okay, but we're also talking about new laws, right? And I'm thinking the Commission, they recently opened an investigation into Google's advertising business. And I'm just wondering, what would the DMA solve that the existing laws that we have cannot solve? I mean, why is it important and relevant to add more laws? MEP Schwab.
Well, in fact, we don't want to add more law. We want to make the existing law more pertinent and want to make it being applied ex ante and not only ex post. We want that compliance with EU law has to be done already when the companies start their work on the computer programs that nowadays are called algorithms, but are pure business practices. And like that, the Commission can intervene much faster, much earlier, and much tougher. And secondly, a single market is only as strong as its laws make it, and as its authorities enforce them. And therefore, obviously, harmonization is the strongest tool that we have to face these companies. And they have taken some advantages from the decentralization of authoritarian powers, as Paul has already mentioned. And for that reason, it's a bit surprising that the member states would like to apply the DMA at the same time. Now, why do they frankly see an advantage there? because they have the experience that in some cases at member states level, there is much less political respect, there is much less political sensitivity when authorities start an investigation compared to the EU level. And therefore, we must make sure that the EU level, Eline, is always strong and facts-driven and is not too much looking to Washington, looking to China, looking somewhere else. Because in the area of competition policy, in the area of market regulation, it's just about applying the law against anyone who is not compliant. And that principle, I think, will help us. And therefore, I think we need a very strong tool to apply the DMA, which is nothing else than a facilitation of existing competition law principles that are well known. And I'm always saying, what is not forbidden, clearly, doesn't mean that it's allowed. But with that area of gray zone, these companies are playing a bit. And unfortunately, there are some companies that are doing that a bit worse than others, but we have to admit that these tipping markets that they control and where they use the power from one market into another is unfortunately something they have in common. There is not the good one. And therefore, we have to make these laws being applied to all of them in the same manner, fixing the problems where they are. And we want to do the best. And we want also to make sure, and I have made myself an amendment on that, that we don't want to allow circumvention of these principles that are in Articles 5 and 6 of the Digital Markets Act, because we want this law to be respected from their value, from their reflection behind, and not by the word of the law.
Thank you very much, MEP Schwab. Yeah, I do agree that there's a strong competition agenda, for instance, also on the US side, but I was wondering whether it'll mean that they will accept our approaches and principles, and I wanted to turn to you, Evangelos, perhaps, because I think the transatlantic relation came up a couple of times in the discussion, and especially on cybersecurity, this is one of the key areas where both partners are working on intensely. And can the EU approach be helpful? Can be supportive of that partnership, or what kind of impact do you foresee?
Yeah, so I can say that the European approach is probably one of the best in the world because it faces the challenges of distributed ownership and cooperation. And this is actually the biggest problem, in cybersecurity, how different states cooperate, to address a problem like this. And in the European Union, we have a tradition now with ENISA, 18 years or 20 years, we have also a regulatory portfolio developed with the NIS Directive 1, now the NIS Directive 2, e-privacy, we have the CSA, the certification. So we are very well advanced, and many countries, a few countries have excellent, cybersecurity capabilities. And we have a very proactive business community, companies who are taking ownership and do a lot of stuff for critical sectors. So I believe that what Europe has done is actually an example for other continents, because this is the only way to solve the problem, to collaborate, to share information and, agree on norms, on standards, and so on. So I think that definitely other continents can benefit from us. And collaborating with the US, which has a very important technology base, as we discussed before, is also actually in quite interesting experience. And also at the public level, public authorities can benefit. This is a sensitive matter, cybersecurity, and the member states obviously have, their own priorities, their own sensitivities. And they have also their own collaboration with the states at individual state level. So the collaboration needs to be properly focused, and there should be proper priorities on this. But absolutely, there should be some dialogues and some discussion. It's absolutely important, and I think other countries can benefit from us, can benefit, from the way that we are addressing and solving the problem. And the knowledge and the experience of ENISA, I can tell you, is already copied, a lot by other organizations. We are, implementing policy. We are helping member states, to be fit for purpose. We are helping them with the capacity. Slowly, we offer other kinds of services like the certification, maybe in the future, be involved in assisting member states in operational cooperation. These are all elements, that other countries find very interesting because this is how they want also to solve the problem themselves. So I think Europe can contribute a lot in this dialogue.
And thank you very much. And also the Commission launched this joint cyber unit, which looks promising to make sure everyone is working together on addressing cybersecurity, because it was quite a terrible year for this indeed. I have a follow-up question, because you've heard Hendrik's comments and concerns regarding, the impact of the DMA potentially on security. How to what extent do you believe that the DMA as a proposal, but also perhaps other digital policy proposals, are focusing enough on cybersecurity and not at the expense, focusing on privacy at the expense of cybersecurity? Do you think there's enough attention paid to that?
I think yes, there is some coverage of the topic of cybersecurity and privacy. These are horizontal matters. We have explained them just before, that they are cross-cutting and they are important not only for technology themselves, for sectors. So there should be an approach to this. And I think there is enough privacy and security aspects covered, not in all policy initiatives, but that's the thing. If you somehow copy and paste, cybersecurity and privacy provisions in different legal instruments, then you have a problem with coordinating this and aligning them and making sure, that they are compatible. So we have to be a little bit careful, how we do these connections, and keep also a focal point where these things stay. Don't forget that technology is an evolving area. And, if we need to update, if we need to change such kind of provisions, it will be very difficult to do this in 5 or 7 different legal instruments. So we have to manage the complexity.
And one more question as well. What is your evaluation or assessment, of the role of the private sector when it comes to... Oh, I'm so sorry. I think you wanted to add. Just first, a quick question for you, Evangelos, and then I go to you, EPP Schwab, if I may. So just please comment on the role of private sector players in how their ecosystem contributes to cybersecurity.
Yeah, look, the assets, the digital assets, are at the hands of the private sector. They are the ones who should be responsible, and they are the ones that actually, do their best to offer the best possible security and privacy. It is in their business interests. We say this many times, and I know that a lot of companies actually do this, and they do investments. They, recruit people. They make sure that they have the right governance structure, and so on. So that's absolutely important. Sometimes, of course, the role of the public sector is different, and there should be a proper division of roles and responsibilities. And but still, a very organization who takes privacy and security, as a key objective is always important, and we say that. And if, however, some companies don't recognize, this, then obviously the legislator, the policymaker comes, to address the gap.
Thank you very much. And back to our legislator then, EPP Schwab. We have time for one last round of reactions.
Yeah, I think we are a bit close to the end of the discussion. I would be very short. I think there can be no doubt that legislation that will be done has to respect the principle of safety of services, of cybersecurity as a common principle. And for sure, private companies that offer services have to make sure that they are resilient and cyber secure. And gatekeepers will have the power and the need to make sure that all offers are respecting this. But we cannot allow that cybersecurity concerns are used somehow as a, if I may say a bit negatively, as a scapegoat for other unfair business practices. So it's up to the gatekeepers in the end to prove that the measures that they have taken are only there and only for that, to make cybersecurity a reality. I think there is still some more information to be given to authorities. But the principle of cybersecurity is accepted all over the place.
Thank you. And I still wanted to ask you one last quick question, EPP Schwab. So, you know, Facebook's Nick Clegg, he said that the EU should avoid laws that would fossilize product design features that would be too specific because it wouldn't work with, you know, given the pace of technological advances. So overall, you know, the criticism is that our laws are not able to keep pace with the technological development. I was wondering, what would you respond to this sort of criticisms?
Well, there are plenty of criticisms, and they are a bit strange because, you know, in the Eastern Republic of Germany, for 50 years, the government, which was not democratically elected, also said, you don't need different offers, you don't need different shops. There will be in every city one shop and you will find everything there. And it has turned out that people have been discovering that in that shop, in the end, there was nothing anymore what they wanted to have. They wanted to have what was offered in the Western German Republic. And that's the best proof that that concept of monopolies being the solution to consumer interests is a fake story. This is ridiculous. The market makes it happen. The market creates the offers that the variety of consumers is looking for. And therefore, we have to make sure that innovation and market development competition is boosted and not what consumers may at first sight like with only one service that they have to operate on. So I think we should always value the argument and being frank and open to discuss about it. And for sure, some arguments are very helpful, but some arguments are also just misleading the debate. And we are aware of that, and we won't fall into any trap with that debate.
Thank you very much, EPP Schwab, and best of luck with this. And I think the message was well received. Hendrik, Bourgeois, I would like to give you the floor one more time before we close the panel, if you have any reactions.
Yeah, no, I just wanted to react to Andreas's comments, which I think to a certain extent were helpful, because he recognizes that companies have legitimate concerns with respect to privacy, security, and safety rights. I think the issue or the problem is that the draft regulation proposes an ex-ante approach, which gives very little room. Which gives very little.
Keep talking, Hendrik. I think it's just a technical problem.
All right. As I was saying, the problem with the ex-ante approach and the regulatory approach which is being proposed in the DMA is that it gives very little room for a real regulatory dialogue with the public authority. What is being proposed in reality is a compliance dialogue, but not a dialogue on whether or not the obligation should be applied in the first place, given existing security, safety, and privacy risks. So that's one problem. And then the other thing that I would like to end up with is that, yes, the DMA is addressing existing challenges that result from one could say the failure of competition law with respect to certain digital platforms. And I would say that the difficulties that competition law has been facing was with business models that are pursuing ad-based business models that collect, process, and sell personal data for advertisement spaces that are able then to sell, zero-priced services and goods. And there's no sufficient distinction in the DMA between the various business models. And because of that lack of distinction, I would argue that it could lead to, undesirable consequences and unexpected consequences. And so I think distinction and differentiation between the business models of those digital players is of extreme importance, because otherwise it could lead to regulatory failure. But I certainly look forward to continue engaging in the debate and the discussions with Andreas Schwab and other members of the European Parliament, and also of the European Council, of course, in this very important legislative initiative. Thank you.
Well, thank you very much, and thank you to the three of you for joining today and for your dynamic. And we have Paulnimitz back. Would you like just 1 minute? You have 1 minute to give us your final comments.
Yes, I would like to react to the statement you've quoted from Facebook and Nick Clegg that the law is always behind. I have created a transatlantic reflection group of academics on democracy and the rule of law in the age of artificial intelligence. And this manifesto is on the internet at the address of the AI Essence Roundtable. And in this group, we have discussed these matters and we found an agreement on very many points which pertain to the relationship between democracy, the rule of law, and the digital sphere. And I think that can make us optimistic that democracy and the rule of law are the prime instruments to deal with the digital future. Let's not kid ourselves. We are discussing here very technical things and they sound like they are only for geeks and insiders. But actually, these rules on how we regulate digital, they determine how democracy functions and how fundamental rights are delivered and how the rule of law functions in the future in both sides of the Atlantic, in the US and in Europe. And that's why it's very important to have a broad engagement in these debates and not leave it to Nick Clegg, and other corporate representatives and the technology geeks and the engineers, but this needs broad engagement and a broad democratic debate.
Thank you very much, Paul. I think this is a great conclusion to our discussion, and I know it doesn't end here, but at least for today, thank you very much again for joining us, the four of you, and thank you to our audience for following. I wish you an excellent day in the company of the Martens Center at the European Ideas Forum. Back to you, Anna.
Thank you, Eline, for that very great debate. Ladies and gentlemen, please join us for a virtual coffee break, and we will see each other again in 15 minutes for an interview with a special guest. Tune in at 11:15.